Viewers, welcome back to the Personal Injury Law Show. We're on that very contentious topic of illegal activities that give rise to accidents and whether the injured person should be compensated. Don, that case there, Miller got paid. I think it's a correct decision. Nuncio disagrees. I think you're on my side. But look,
right.
The offending driver's, subject to the penal law, so criminal codes, and will get penalised there. And I don't
the
see
driver
why.
got 5 years imprisonment, I think it was.
He did.
Yeah.
He got charged with culpable driving because one of the passengers died in the accident.
And I don't see why the injured person that wants to get out in circumstances, apart from just jumping out of a car, I don't know what to do.
But
What
Tony,
you could possibly do.
The plaintiff wasn't charged with theft. I still can't see how she would.
Oh, they felt sorry for it. They felt sorry for it. Yeah. At the end of the day, she's got horrific injuries, and I've seen it. I've seen it in my career. They actually, sometimes the police, in their wisdom, don't charge someone because it's a summary offence. No, theft of car is indictable. Yeah. But they did not charge her in their wisdom because she's got massive injuries.
Okay.
Yeah.
And the Western Australian law is a little bit different. They do have in their criminal code, if you're no longer a part of the joint illegal enterprise, either by verbally or you withdraw from it, so therefore you cannot be charged, essentially.
Don, when did you want to become a criminal lawyer?
No, that's right.
Let's get on to the next topic of causation in motor traffic accidents. Can a road sign cause an accident? This is what this case is about. It's Roads Corporation and Dykes. It was originally in the county court and went up to the Court of Appeal in Victoria. Give us the facts of that case, please, Don.
Well, look, I know this area of road really well. I used to drive up and down that highway many times to go to work.
Did you make the same mistake?
No, I didn't. It's in the Gippsland area in Druin. Mr. Dykes was driving to work and had done so for about 12 months on that route. And he was heading towards the entrance of the Princess Freeway, off Princess Way. And instead of turning at the freeway entrance, he turned at a secondary road because he looked at a sign. There was a sign which is called an advanced direction sign, which indicated coming up is Melbourne. So he turned left, thinking that was the entrance of the freeway.
But he couldn't see the proper signage that would tell him where to turn.
That's right. If our viewers from Gippsland, as they know, when a fog hits, it's very, very dense. The evidence was that he could only see 10 to 20 metres in front, and it was at 5:30 in the morning.
It's very interesting you say that, because when I left Essendon this morning, I couldn't see outside my driveway. Then once I get to Lygon Street, which is only 10 kilometres, it was beautiful and sunny. I rang up my wife and said we should be out there having breakfast. But anyway,
so the driver, Mr. Dykes, he couldn't see further than 10 to 20 metres. He gets up to this advanced sign, thinking that that's a sign he should turn off onto the freeway, and he turned off. It was a secondary road, goes off and hits a tree.
Well, can I stop you there for a second? Nonce, he's been up and down this road for 12 months. Is he just plain sleepy or tired?
Look, I found it very odd.
Clumsy or...
In reading this, at the start I didn't realise how many times actually gone past this section of road, and hearing for 12 months, and he's an experienced truck driver, I found it very odd that now this is the cause of the incident. Yeah. Plus, look, he was going, I think, 85 kilometres an hour, and look,
in those conditions.
I don't know about you, when it's foggy like that, I try and slow down and make sure that I can see in front of me.
Well, the only risk behind that is if you do slow down and drive at a slow speed,
hit from behind.
They actually said that in the case.
That's right. When I worked in Gippsland, there was many cases like that where it's foggy and someone's just hit another car in front because they're driving too slow.
I think we might have to open up an office in Gippsland. A number of accidents happening down there.
So it can happen. And in Mr. Dykes' case, they actually did raise that there was a number of cues even before he hit that sign that he should have been aware of. Like there was a couple of signs beforehand which said 300 metres was another. Yeah. There was a Druin racecourse which is near the turnoff.
No, look, in short, what did he win? He won his case.
Look, he won his case. It was the court found at first instance that it was reasonably foreseeable by placing that sign, and even we should take into account the fog lines. The fog lines, those lines, the white lines on the side of the road, that they actually, between the signage and the fog lines veering off to that secondary road, it was confusing to the driver. So it was reasonably foreseeable that in those circumstances an injury like this could happen, an accident.
The counsel in this case, it was within their knowledge, or if they applied some thought to the process, that this would happen. That's what foreseeability means.
Yeah. There was no complaints about the sign before this accident. There was no complaints on record anyway it was Vic Roads. They did bring in evidence of people who knew the road and said they were confused. There was 2 witnesses, one who lived on a secondary road who said that on many occasions there would be cars that turn down the secondary road and do a U-turn, and from that the court inferred that they actually were confused by the signs. And there was another driver who said on 2 occasions he actually turned off on the secondary road because of this confusion. But it was never reported to Vic Roads before. It was only reported afterwards.
I don't think it was contentious that he couldn't see the proper sign. That was not really an issue, was it?
No, he couldn't. No, that's right. I mean, he was confused because at the time of the in the morning with the fog, the only part that he could see of that sign was the bottom part, which was the same sign that directed him to move into the Princess Freeway further down the road.
I think ultimately, though, I think there was 4 factors ultimately. 1 was the geography of the sign where it was placed.
Yep.
2 was actually the signage. 3 was the broken fog lines, and 4 was the fog itself. They were the 4 factors that effectively the court...
It went into the melting pot.
Yeah.
Yep.
Nonce,
Yep.
would it surprise you got $333,492 after a reduction for a third? But listen to this, the reduction wasn't so much for what you said that he'd been down there for 12 months. It was because he was going too fast.
That's what I can understand, Tony.
Yeah.
You know, he was. You know, they say that he was going at the right pace because obviously can't go too quick, can't go too fast. But what was the right speed?
That's
Was
right.
this a good decision, Don?
Look, I think it was a good decision. I mean, the duty of care is on Vic Roads to look after their motorists who use the road, and obviously a sign like this can confuse them. And in fact, I think they're starting to move away from these type of signs. You can see on Eastlink, there's those directional signs, advanced directional signs, but they actually, if there's a secondary road, it will point to the secondary road.
And they're like
so
2
can't get
kilometres
confused.
out. And,
Yeah.
What, the part of the judgment I wasn't happy with was the third reduction. I thought that was too much. That's
He had a
my-
major. It was a brain.
Well, going through his injuries, he sustained closed head injury, facial fractures, facial scarring, an injury to his neck. He had complete loss of smell. He had continual headaches, osteoarthritis in his knee. All credit to Mr. Dykes. He actually has returned to work.
Stoic guy.
Yeah, but the judge said that he wouldn't be able to last in that employment for the next, only for about 10 years, so
think
therefore
if
compensated from there on.
I think a third was too much to come off.
What should have been, Tony?
For me, maybe 10-15%.
Yeah, no, look, I think...
Because of the circumstances. I mean, you know, it was foggy, couldn't see, you slow down, someone runs up the backside, and so you injure someone else.
Yep.
You go too fast, and this happens. I mean, I don't know, 10 or 15% would have been fair.
Sure.
What would you have taken off? 50?
No, look-
50.
No, I said I couldn't work out why it was a third. That's what my issue is with that. Because what was the right
I'm
speed?
also disappointed with the general damages in this, which is a pain and suffering component. I think it should have got more.
Well, he was assessed at 225.
How old was he?
Which was in the range that the council, the plaintiff council, put to him. He was, look, the accident happened many years ago. He was 38 at the time, now 47.
Okay.
Yeah, 38's very young.
Yeah.
You know, I guess there's an upper limit on what you can get for pain and suffering.
Sure.
You know? But still, this is one that he's going to suffer for a long time. So I would have thought 300,000 plus just for that alone would have sufficed.
Yeah. So look, it was in the range that their council put to the court.
We could go on about this topic forever, but look, it's coming towards a time where we've got to get to the mailbag. So, Don, I appreciate you coming on board again. Nunce, you're going to have a breather this time.
Yeah, Don's staying put now, so I'm off.
Yeah, thanks for coming on.
No, I appreciate it. Thanks, Don.
Viewers, please don't go away. Stay tuned. We'll be back with Kathy's mailbag just after the break. Thank you.